Welcome to the deep dive. Today, we're digging into a pretty complex piece of legislation, Bill number 14048.
Right, it's about state supervision over local self-governance. Sounds dry, maybe?
Yeah, it sounds like typical regulatory stuff. But the analysis we're looking at today paints a very different picture.
It really does. Our source, a critique from municipal law experts, calls it a civilizational turn. That's quite a statement.
It is. They argue this isn't just tweaking oversight rules.
No, they see it as a blueprint for, well, centralized control, drafted by officials for officials.
And the purpose, according to them.
Basically creating the perfect setup for, and this is a direct quote, unpunished communal plunder.
Wow. Okay. And the source highlights the citizen's role in all this.
Or lack thereof. They
Yeah.
call the citizen the forgotten hero in this whole proposed system.
To really get why they're so alarmed, they use this analogy. It's quite vivid.
Yeah, it really brings it home.
Imagine you find someone actively robbing your house.
Right. What do you do? Call the police, obviously.
But under this analogy, for the law, you can't do that immediately. First, you have to sit down and write a very polite, formal demand to the robbers.
Asking them to please stop robbing you.
Exactly. And then you wait for 20 working days, almost a month, for them to reply.
And meanwhile,
Meanwhile, your stuff is being, legally laundered and driven away.
that analogy perfectly captures the critique's core argument. It's about engineered delay.
So the claim is this bill builds a kind of rigid, centralized power structure.
Yes, worryingly similar, they argue, to authoritarian models, like you might see in the Russian Federation. And delay is the key tool.
It's framed as an existential threat to local self-governance itself.
Pretty much, yeah.
Okay, so let's break down that timeline. How exactly does this bill allegedly give corrupt actors this huge head start? Almost 3 months, you said.
Right, let's trace the path. First step, a local council passes an illegal decision.
Okay, what kind of decision are we talking about?
Could be anything, really. Selling off a historic building for pennies, maybe? Or handing over protected forest land to a developer?
Or even just funneling budget money to, a shell company.
Exactly. Clear abuse of power.
So, the crime happens. Now, normally, wouldn't that trigger an immediate criminal investigation?
It should. The source points out that under current law, Article 365 of the Criminal Code on abuse of power, that's mandatory. Immediate criminal action.
But this bill changes that.
It overrides it. Instead of police and prosecutors, the process starts with the state supervisor.
And who is this supervisor?
They're the head of the Regional State Administration, the RSA. Importantly, appointed directly from Kyiv, not locally elected.
Okay, so this Kyiv appointee starts what? An administrative review.
Yes. And here's the first delay. They get a full 60 days just to notice the violation.
60 days just to notice something potentially illegal happening with public assets. That seems generous.
It seems intentional, according to the critique. It's the first layer of protection for whoever pushed the illegal decision through.
Okay, so after 2 months, the supervisor finally notices. What next? Do they go to court?
Nope. Still no court action. Now they have to send that formal, polite demand we talked about in the analogy.
The one asking the council to please reconsider their illegal action.
Precisely. And the council gets another 20 working days. That's nearly another full calendar month just to respond to the demand.
So let me get this straight. 60 days to notice plus almost 30 days for a response.
You're looking at roughly 3 months, give or take. 3 months of mandatory, legally required inaction from the state oversight body.
While the illegal action proceeds unchecked.
Exactly. And that's the whole point, the critique argues. That's the mechanism for, well, laundering the decision.
How so?
During those 90-odd days, the damage gets done. The historic building, it's demolished. The forest land is rezoned or construction starts. The budget funds, transferred, spent, gone.
So the consequences become irreversible before the supervisor is even required to take meaningful action.
That's the claim. The crime is effectively completed, the assets are gone or transformed, and only then, after the plunder is basically finalized, does the supervisor even face the possibility of going to court.
And here's the part the source finds particularly dangerous. After all that delay, what happens?
It gets worse. The supervisor then gets to unilaterally decide whether to take the case to court or not. It's entirely up to them.
So it's not automatic even then.
Not at all. And this, the source says, creates ideal conditions for forming organized criminal groups, OCGs.
How does that connection work?
Well, think about it. If you're a corrupt local group, all you need is influence over one person, that state-appointed supervisor.
Your pocket supervisor.
Right. Someone politically motivated, or perhaps incentivized in other ways, who just forgets to appeal, or decides not to challenge the illegal decision in court.
And if they don't appeal?
Their inaction effectively gives the illegal plunder a green light. It ensures impunity. The system itself protects the wrongdoing through deliberate delay and discretionary enforcement.
So the very design encourages finding compliant supervisors. Which brings us to the next point. Who are these supervisors supposed to be? What kind of person is being put in this powerful position?
That's the second major area of critique, the institutional conflict built into who gets chosen.
Okay.
The bill suggests these heads of RSAs, the supervisors, should have experience either in state service or in business.
All right, seems reasonable on the surface. Experience is good, right?
Well, the critique argues this specific kind of experience fundamentally clashes with the philosophy needed for genuine local self-governance.
How so? What's the conflict?
Think about the typical mindset. A career civil servant is often trained in a very hierarchical system. The rule is often only do what the instructions explicitly allows.
Very rigid. Follow the rules, don't deviate.
Exactly. And a traditional business person. Their primary focus is usually on financial results, profit, efficiency within a defined structure.
Okay, I see the mindsets. How does that clash with local government?
Because the European principle of local self-governance, the one we supposedly aspire to, is based on the opposite idea. Everything not explicitly forbidden by law is allowed.
So it requires initiative, creativity.
Precisely. Local communities need leaders who can find innovative, non-standard solutions for their specific local problems. It requires thinking outside the rigid instruction box.
So if you appoint a supervisor trained to think only inside the box...
They're institutionally programmed to see local initiative not as good governance, but as a potential violation of instruction. Any creative local solution looks suspicious to them.
Instead of facilitating, they become a bottleneck.
A powerful one. They stifle the very creativity local governance needs. And this, the source argues, immediately creates a huge potential for corruption.
How does that link to corruption?
Well, imagine a community wants to do something innovative, build a unique tech park, start a special local tourism program, anything not covered by standard procedures. Suddenly, it's not about just following the law. It requires negotiating with this supervisor, getting their permission, overcoming their inherent suspicion of anything novel. It turns governance into administrative bargaining.
Want to build your park? Let's talk. That kind of thing.
Exactly. It makes permission dependent on the supervisor's goodwill, or perhaps other incentives, rather than legal compliance.
And this preference for top-down control, this suspicion of local initiative, this is where the comparison to other systems comes in.
Yes. This is why the source calls it a copy of the philosophy of management, found in places like the Russian Federation. They use the term unified system of public power.
It's not just about Russia, though, is it? The source mentions our own history.
Right. They argue we've seen versions of this before under past governments like Kuchma or Yanukovych. Remember the smatriashti?
The local overseers,
Yeah.
appointed figures who answered only to Kiev, not the local population.
Exactly. They bypassed local democracy entirely. The argument is that this centralized system never really went away. It just got quieter.
And now it's trying to come back using more sophisticated legal tools like this bill.
That's the fear. That bill, #14048, is the modern mechanism to restore that kind of manual top-down control.
Can we make that comparison more concrete? What are the specific parallels the source draws between this bill and, say, the Russian system?
Okay, several key points. First, the appointment of cadres. This bill has the heads of RSA, the supervisors, chosen centrally in Kiev. Loyalty upwards is key.
And the parallel.
In the RF system, governors, mayors, they're essentially part of a Kremlin-controlled vertical. Loyalty flows up.
Got it. What else?
The administrative veto power. This bill gives the Ukrainian official, the supervisor, the power to essentially block almost any local decision without going to court first.
So they act as judge and jury themselves, administratively.
In effect, yes. Which mirrors, the source argues, the broad powers of direct interference that prosecutors or governors have in the Russian system to quash local decisions.
And the scope of this supervision, is it limited?
That's the third point. It's total. Supervision under this bill extends to all decisions of local councils, even very minor ones.
All decisions.
Yeah. Which means, theoretically, any local action, no matter how beneficial or mundane, could be challenged and potentially canceled from above just on formal grounds. A misplaced comma could be an excuse.
That sounds paralyzing for local government.
It creates a climate of fear and deference to the supervisor. The conclusion drawn by the source is pretty stark.
Hmm.
This bill represents a choice, a pivot away from the European path of decentralization, which is built on trust and local empowerment,
Towards what?
towards an authoritarian model built on total distrust of local actors and the need for manual control from the center.
Okay, so if the analysis is that this bill is fundamentally flawed, designed for control and delay, and needs to be rejected entirely, what's the alternative? You can't just have no oversight.
Absolutely not. The critique doesn't argue for anarchy. It proposes a constructive alternative, one that actually empowers citizens and uses existing laws.
Existing laws, like what?
Specifically, the law on self-organization of the population. This law already provides a framework for a three-tier model of local governance.
3 tiers. Okay, break that down for us.
So Tier 1 is the basic level, like the House-level OSN body for self-organization of the population. Think of it as the neighborhood watch, the basic nervous system.
Simple enough.
But the really crucial level, the heart of this alternative, is Tier 2, the microdistrict level OSN.
Micro-district, like a larger neighborhood or a section of a town.
Exactly. And this isn't just some advisory committee. The vision here is for a full-fledged, properly elected representative body for that area.
Elected by the people living there.
Yes.
Yeah.
And critically, it would have delegated real powers and finances.
Okay, real powers and finances. What does that mean in practice? Where does the money come from?
It means this microdistrict OSN manages its own budget. The money could come from genuinely local revenue sources, things like local parking fees, maybe revenue from local advertising, billboards, that sort of thing.
Stuff generated right there in the microdistrict.
Ideally, yes. And beyond budget, it acts as the primary community controller for local services, checking the quality of trash collection, street cleaning, things like that. It also partners directly with the local police officer, the local clinic, or doctor.
So it becomes the day-to-day interface for local power, where people's power actually happens on the streets.
That's the idea.
Yeah.
It makes local governance tangible and accountable at a very granular level.
And the third tier?
The third tier would be the district council. But instead of being filled with traditional career politicians, the idea is it would be composed primarily of the proven effective heads of these microdistrict OSNs.
So people who've already shown they can manage things effectively on the ground.
Right. Practical experience, direct accountability to their microdistrict, moving up to the district level.
Okay, that structure seems to empower the local community significantly. But what about supervision? How do you prevent this local council or OSN from acting illegally or corruptly without bringing back that 3-month delay problem from Bill #14048?
The supervision model shifts focus entirely. It's not about a political appointee controlling everything. It's about protecting the public rights of the community members themselves.
Protecting citizens' rights. Okay, who does that?
The source argues the most appropriate body for this specific role is the prosecutor's office.
The prosecutor. Interesting. How would that work differently?
They wouldn't be acting as an administrative controller like the RSA head in Bill 14048. Instead, they act as the state advocate, specifically for community rights.
A state advocate for
Yeah.
the community, against its own government sometimes.
Potentially, yes. Let's say the elected local council tries to do something that violates the collective rights of people in a microdistrict, like pushing through an unpopular, harmful development project.
Okay.
The microdistrict OSN, representing the affected residents, would appeal to the prosecutor's office.
And then?
The OSN and the prosecutor's office would jointly go to court to defend the community's interests against the decision of their own elected local government.
So the check and balance is a legal one, through the courts, initiated by the organized community itself with the state's legal backing.
Exactly. Power answers directly to its voters and their representatives in a court of law, not to a political appointee miles away.
That's a fundamental difference. What about bigger issues like serious corruption or, say, separatism? Does the prosecutor still play a role?
Absolutely. The prosecutor's office retains its crucial traditional role in protecting wider state interests. So if there's evidence of major financial corruption, abuse of power impacting state funds, or actions threatening national security...
And they act directly.
Yes. In those serious cases, they are mandated to immediately open criminal proceedings. No 60-day waiting period, no 20-day demand letters. They investigate and prosecute the crime directly, protecting both state and public interests without the built-in delays.
So it provides immediate intervention for serious crimes, but empowers the community itself to handle routine oversight of its own rights through legal channels.
That's the balance the alternative model aims for.
This deep dive really lays bare a fundamental conflict, doesn't it? The source presents it as a choice between two very different paths.
It really does. On one hand, the path suggested by Bill #14048, centralization, distrust of local actors, control through administrative delay and political appointees, an authoritarian-leaning model, they'd argue.
And on the other hand,
The European path, decentralization, empowering organized citizens, using legal mechanisms for accountability, building trust from the ground up.
what strikes me about the alternative model is the feedback loop it creates.
That's critical. It creates immediate, living feedback. If local officials know that any illegal or harmful decision won't just be reviewed slowly by some distant supervisor.
But challenged quickly in court by their own voters, organized voters with actual legal standing, and potentially the prosecutor's office beside them.
Exactly. That forces a completely different kind of accountability. It's direct, it's local, and it's potentially very swift. Far more effective, the argument goes, than any system based on centralized delay.
So it really comes down to where you place the trust and the power, with central bureaucracy or with organized communities. Which leads us to a final thought for you, our listener.
Yeah, something to ponder.
If the way a system governs is defined by how quickly and effectively it intervenes when things go wrong, especially with corruption, what does that mandatory 20 working day waiting period for a simple response tell you?
Whose interest, really, is a system with that kind of built-in delay designed to protect.